Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in today's video, I'm going to talk about one of the most misunderstood parts of defending a debt collection lawsuit, and that's the use of written discovery. But if this is your first time here to my YouTube channel, go ahead and click subscribe. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. Let's talk about written discovery. And if this is your first video you're watching from my YouTube channel, this is actually one video of a 5-part series that I'm doing here in 2022 on how to defend a debt collection lawsuit. So this is video number 3, where we're going to talk about discovery, written discovery, what it is specifically, what you should do if the debt collector serves you with written discovery, and whether or not you should serve them with written discovery. And this can be a very important part of the case that's often overlooked by non-lawyers as you're going through this. So let's talk about what it is first of all. Discovery can take a few different forms or types. It can be pretty basic. In most civil cases, you're required to file something called an initial disclosure in most states. That is essentially you have to disclose just voluntarily any documents you may have related to the case or any witnesses you intend to use, defenses you're going to put forward. And the same is also true for the debt buyer, the debt collector who's suing you. They've got to provide monthly statements, list of witnesses, how much they're actually seeking from you. And typically those have to be exchanged between the parties. Usually these are not documents that are filed with the court. And that's true of most discovery requests and responses. They're not submitted to the court for them to review. It's just done between the parties. It also takes the form, and this may be a little bit more familiar if you're in a case right now, of written questions, requesting documents, requesting information, or requesting for you to admit certain facts. They really fall into 3 categories when we're talking about written discovery: interrogatories, which are written questions that they're sending to you or that you're sending to them where you're trying to get information; requests for production, which are usually requests for documents. So they send you a request asking for whatever, monthly statements, or vice versa. You're sending them a request asking for the original contract. That's a request for production. And then the third category is requests for admissions. These are really, they are what they sound like. You're asking the other party to admit or deny certain things. It's where they're asking very detailed, specific questions of whether you admit or deny a certain fact. It's not meant to, be like an interrogatory where there's you can expound on it. Basically, it's a yes or no type question. Now, these types of discovery you will see often from debt collectors. They will send over to you, and you're required to respond to them. So let's go into that part. If they send you written discovery request, how do you respond to it? First, you need to know how much time you have to respond. In some jurisdictions, in Arizona, if your case is in the Justice Court, it's going to say on there how much time you have to respond. Right now, that's 40 days from the day that they send it to you. That rule has changed a little bit in Arizona, so if you're watching this at a later date, you want to double check that. Other states, it might be 30 days. But if they often, and I can tell you why they usually do it. Usually the debt buyer or the debt collector, their attorneys are sending you discovery requests not because they really want to get information from you, but because they're trying to lay a trap for you.
It's a trap!
And that is in particular with the document called request for admissions. Like I said, the requests for admissions are very simple. They may send something over to you and it might say, admit that we are the proper owners of these documents or of this debt. Admit that we are that all of our documents are admissible into court. Admit that we've calculated the damages correctly, or whatever it is. And you may be thinking, well, I don't know that, or I would need to get more information, I'm not sure. Here's the kicker when it comes to requests for admissions. If you don't respond within the timeline, in most jurisdictions, they're deemed admitted. And so that's the trap that they're trying to lay there, is they may send something over and you're like, this is stupid. They're asking me to admit essentially all the elements of their case. And that's exactly what they're doing. They want you to admit that, or admit it by failing to respond in a timely manner. And then they will attach that to a motion for summary judgment and try to win the case on a technicality like that. So it's important, if you receive those, you look on the document themselves or check the rules of civil procedure and determine in your state how much time you have to respond to it. Now, the kind of another question, and kind of the third area we can go into, is whether you should send discovery requests to the debt collector. Now, I can tell you in junk debt buyer cases, I know what a lot of people think, because they talk about this when they come into my law office here in Arizona. They're like, you know what, they haven't provided me anything. They don't have a lot of documentation. I don't think they can prove that they're the owners of this account. So I'm going to send over to them requests for admissions and ask for all their documents and force them to give me those documents. And I get it. I get that thinking of, you're like, hey, where's the evidence? They better provide this or there's going to be trouble, kind of thing. And it's true, there is trouble if they can't provide it, and if they don't have evidence that they're the owner of the account, if they don't have evidence of how they calculated the amount that's owed. If they can't prove all of that, they're not going to win their case. You always have to remember the plaintiff, the debt collector, they bear the burden of proof in your case, and they have to prove all of those elements. They have to prove that you had the account, they have to prove what the amount owed was, they have to prove that it was transferred to them or assigned to them. And if they can't prove any of those things, then you win. You don't have to disprove it. You can sit back and kind of pick apart their case. And so I always say to be careful, show a little bit of caution in what you're requesting, because sometimes they don't have those documents, but if you request it, they'll actually go back to the original creditor and get it. And so it kind of backfires on you. So I don't do a lot of written discovery requests of the other side. I take the position of, hey, they can prove it or they can't. They have the documents or they don't, but I'm not going to be the one that's going to force them to go get it, because if they don't have it, that's better for me and it's better for my client. Now, I'm going to put a link down below this to some templates, an online tutorial I have that really does a deep dive into discovery, responding to it, and whether you should, there's some instances where it's not a bad idea to send discovery over to them. Also, if you're in the state of Arizona, I handle these cases all the time. I'm happy to talk to you about your case in more detail. So check those things out. I hope that's helpful. Check us out. The first 2 prior videos are on how to draft an answer to a debt collection lawsuit. The video after that was how to get the case dismissed by compelling private arbitration. And tomorrow we're going to talk about the biggest hurdle for almost all unrepresented people in court, and that's the motion for summary judgment. Thanks for watching today.